The Committee of the Whole is back from recess. We are still on Senator Titlegy. I believe you wanted to proffer an amendment, and just for your information, Senator, your 5 minutes is up, but please offer your amendment.
Thank you, Madam Chair. Madam Chair, I'm going to yield I'd written amendment, Madam Chair, but after collaborating with senators, I think there's another amendment that would probably be, without making all the changes in mine, best to just withdraw my amendment and then allow that senator to introduce his amendment.
Thank you very much, Senator Titlegy. There is no amendment to the amendment. On the amendment, Senator San Agustin, you are recognized.
Thank you, Madam Chair. On the amendment, I'd like to proffer an amendment. It should be on the drive, and I know that my colleagues have all received a copy. My amendment basically, let me see. If my colleagues would just take a few minutes to read it first, and then we can go over it versus the amendment that was proffered by the author of the amendment that I'm offering an amendment to. Generally speaking, what the amendment does is to appropriate the funds from the general fund to the war claims fund, like everyone would like to see it go. And that, as you move down, and it's double underlined, is that and that's, as my other colleagues had mentioned, that they would prefer to get it.
Senator, we'll take a brief recess so everyone can find this amendment.
Okay.
Thank you. The committee of the whole is back from recess. We had an amendment offered by Senator Joseph Augustine. Sir, you have already spoken on this amendment, and so I will recognize Senator Clint Ridgell.
Thank you, Madam Chair. The amendment is to line 18, 23, page 7, line 18 through 23, page 7. The amendment would now read, "B, upon full expenditure of such funds under subsection A of the section, the sum of $10 million is hereby appropriated from the general fund balance of the revenues collected in excess of the adopted FY 2021 revenues to the Guam War Claims Fund for the payment of claims approved by the Adjudication Committee and certified by the chairperson. Imagahagan Guahan shall submit a fund transfer report regarding each transfer from the general fund to the War Claims Fund. Section 30 funds made available in FY 2023 may be used to reimburse the general fund to recoup all amounts authorized by the subsection as identified in the fund transfer report executed by Imagahagan Guahan. A copy of such written report shall be delivered to Legislature in Guahan within 15 days upon execution. This fund shall be exempt from the governor's transfer authority, and any funds remaining shall be subject to legislative appropriation." So what this amendment does is it attempts to incorporate certain major themes from some of the other amendments that have been proffered and discussed. And so the idea is to incorporate some of what some other of our colleagues would like to see into one amendment here.
Thank you very much, Senator Ridgell. On the amendment to the amendment, Senator Brown?
Thank you very much, Madam Chair. I'm in agreement probably with most of this amendment, but I do have one major disagreement, and that's with the word "may." As I mentioned in my previous comments earlier today, I'm very much of the opinion that with regards to these funds going to pay our remaining war survivors, that should come from a federal source, and that specifically at this point, and as was determined by Congress previously, that it should come from the Section 30 funds, because at least that is coming from federal sources in terms of the money that's reimbursed back to Guam for the military personnel that have been assigned to the island. I think that's critical. Otherwise, we are simply, as I mentioned earlier, literally having the victims on Guam pay for their own compensation out of their own funds. You know, this whole idea of taking the drop of water that we may call the Section 30 fund and putting it into the pond of water that we call the general fund and say, oh, well, you know, it's all together. I don't think so. I think as this amendment outlines a specific source of how and when and while, and the governor's going to report and all those wonderful things, but if we don't identify that shall come from the general fund, I think it doesn't follow through with what is an expectation, even though it's a lowered expectation than others that have been compensated by the federal government with regards to injuries and atrocities suffered during World War II. And I think, colleagues, with all the challenges that our people are currently experiencing, I mean, we have a responsibility here in the legislature to be the trust of the public purse, to ensure that we are properly spending the funds of our people. And I think we need to distinguish between the monies that we identify as general fund revenues versus the federal money of Section 30. I mean, right now, we simply cannot, and the concerns are there, even provide adequate education for our children. We already see those issues coming up right now. I mean, just even because of this pandemic, we can't even have consistent teaching in the classroom to ensure that our children are properly learning. And we're now going on year 3. We cannot ensure, and even though, you know, the governor made a big pronouncement last week about increasing the compensation to law enforcement, it's unfortunate because it's across the board, which still puts the Guam police at the bottom of that list. But we can't ensure the personal safety of our people. Our people put bars on their houses, put cameras out on their houses, put fences around their houses to protect themselves because they can't even feel safe in their own community now. We can't even ensure that, you know, we're going to go into our supermarkets and even have a consistent supply of food for our people right now. We can't even do that with the general fund money. And we just can't turn a blind eye to those realities because even though we say excess, we cannot even fund these things now. So I think it's critical that we distinguish between what is the general fund revenues that we have and the federal funding, which is where this money should come from. Because what are you going to do? Are we going to turn a blind eye? Look away? Or even now earlier, let's close our ears and not hear the concerns of our people out in our community? We have a responsibility to ensure how the public funds are spent, and I think it's critical that we carefully and very clearly distinguish how the public funds are spent. We shouldn't think of ourselves as elite here in the Guam Legislature and not be aware of the challenges that are facing our people out there, because we can't fund these demands and needs of our people right now. We'd like to say it, it's an election year, and boy, don't we want to go out there and tell them all the great things that we're giving them. Certainly the administration's doing a wonderful job of that. I can't imagine what more we're going to hear in the next few months leading up to the election. But this particular issue demands that our people be compensated from a federal source. Otherwise, we cannot say we're giving them public acknowledgement and proper recognition. Because we cannot put ourselves up on the pedestal thinking that we somehow are in our position to do that. This is an obligation of the federal government. Unfortunately, after much effort from many of our congressional representatives, we've not been able to get it at a level of where it should be. Because our people are getting less than anyone else that's since been compensated by the US federal government. And we know who they are. And yet we're settling because what choice do we have but for us to further subjugate our people by having these funds come from the general fund and not from Section 30. I object. I think we must change the language from may to shall come from the general fund, from Section 30, not from the general fund, but specifically from Section 30 monies. And then I can actually vote for this bill. I think it's an acknowledgement that's necessary. Thank you, Madam Chair, for the opportunity to comment on this amendment.
Thank you, Senator Brown. On the amendment, Senator Teitigl, you are recognized.
Just Masi, Madam Chair, and I'll try and make this very short. I see there was a compromise made, and my concern was ensuring that Section 30 funding was and able to be available for this section with regards to reimbursement. Now, even though it says may, it doesn't stop this body, this legislature, from ensuring that once we have Section 30 money, which is our responsibility to appropriate, is given to as a reimbursement for using any kind of funds that were used today. I mean, it said that in the next couple months, they're hoping to start making the payouts for individuals. And I don't think that any of our people should wait any longer for it. But I do support the amendment to the amendment that incorporates Section 30, mentions Section 30, and though it says may, I understand the good senator, and understand that shall should be there. It forces the governor to do so, but I think this body all agrees that we should maintain that same type of payment that the other recipients received. Oh, shoot. No, I'm not going to do it. I can't. So that, Madam Chair, I stand in support of the amendment. Thank you, Madam Chair.
Thank you, Senator Teitigl. On the amendment to the amendment, Senator Blas, you are recognized, followed by Senator Duenas.
Thank you, Madam Chair. Madam Chair, I have to agree about the concerns that were brought up by the good senator from Pago Bay, and I want to go ahead and make and proffer that amendment to change the word may to shall.
There has been an amendment proposed to the amendment to change the word may to shall. If there's no objection to proceeding, we'll take a moment's recess. The committee of the whole is back from recess. We were entertaining an amendment to the amendment to the amendment. Unfortunately, we have exceeded the limit of amending the amendment, and so I will not entertain that amendment. But Senator Blas, if you'd like to speak on the amendment, you have the floor, sir.
Thank you, Madam Chair. I'll defer until the amendment is disposed of.
Thank you very much. We're still on the amendment to the amendment.
If I could just make a point of order.
Please state your point of order.
Yeah, the amendment form is just not clear, so I'd just like to make it clear that in the second line, the only words that are being added to my amendment are, they're deleting FY 2021, and they're adding the words balance of the. And the rest of the language was already in the amendment. And then they're adding the sentence, Imagahagan Guahan shall submit all the way to 15 days upon execution. And the last sentence was again already in the amendment, but it's double underlined in this form, so I think that's confusing.
Okay, thank you very much, Speaker, for that clarification. Senator Dueñas, you are recognized on the amendment to the amendment.
Sijus Masi, Madam Chair, and certainly rise in support of the amendment. You know, in my discussion on the original amendment, the reason why I was going down the road of recognizing the revenues under Section 30 was that was my original amendment for actually fiscal year 2022. But in conferring with others, there was some discussion back and forth as to whether that's budget has passed, you know, whether or not that would create a problem. So I agreed with this change for the fundamental reason, Madam Chair, is everything comes from the general fund. When the 35th Guam Legislature went down the road of advancing the revenue, it was the general fund that supported that. In this anticipation now, which is fine, in looking forward to fiscal year 2023, we're essentially going in, Madam Chair, and then ensuring that that revenue has the option, and as a retiring speaker as well said, when we address that budget in this fiscal year, those funds then under that Section 30 will become not available for appropriation. Recognized, reimbursed, but it will still change the Section 30 amounts recognized in fiscal year 2023. My only point is, this amendment as proffered to begin with, Madam Chair, is a recognition of what are our priorities. When we were entertaining the LEAP, as the 64 million unaudited was identified for 2021, that was one of the items. This $10 million for this program that was identified. We are engaged in an exercise of accounting. I certainly have absolutely no problem, and as I said, was actually attempting to do 2022. Because we know that that money for Section 30 will be coming in September. What we literally do and will be doing when we go into 2023 is identifying funds available for appropriation. And at the top of that list is going to come in whatever estimate we have for Section 30. More than likely somewhere around $77 million upwards. But we'll recognize, if this amendment passes the way it is, that there would be $10 million less that's going to be reimbursing the general fund revenue that we used. So I just want to, make sure we understand, all of us are interested in accountability to this process. All of us recognize that this literally should be a federal recognition. to exercise accounting to put it into the fiscal year, into the Section 30 funds is appropriate. Maybe someday when we go forward and have an opportunity to re-adjudicate this case with the national government, at least we can say, we recognized your reimbursement as for other federal activities on Guam as the source of revenue. But make no mistake about it, we use the general fund. We used it then, we're going to use it now, we're going to reimburse ourselves. But that's the obligation that this legislature, along with the governor who wanted to do this program going forward, said we would do. We would do this justice. It is our money, no matter any way you look at it. Because the money available for appropriation in the fiscal year 2023 is money that would have been available for public safety, health care, education. It's still going to be put into our priority at this moment. Cesar Masi, Madam Chair.
Thank you very much, Senator Dueñas. On the amendment to the amendment, Speaker Terlahi, you are recognized.
Thank you, Madam Chair. I don't object to adding a provision that says future legislature may reimburse the general fund from Section 30 monies, but I am glad to see the language remain in here that we are going to use the revenues collected in excess of the adopted FY 2021 revenues, because that is the language that we received from this administration in every fiscal note that we have received on this bill and other bills as to where can we get money to pay for these programs. When the legislature passed in October 2021 the original Local War Claims Bill 130, it was unanimous. And we all agreed, and so did the governor who signed that bill into law, that we could and would fund this program using the same level of appropriations that we had authorized already for FY 2022, and the same amount of revenue that we had recognized already, and simply transfer from savings in various agencies or other savings and expenditures into the War Claims Fund. That was unanimous, and every single senator voted for it. No one said we can't do it unless we use Section 30 funds, because we were trying as fast as we could to fund the program. And while I agree with reminding the world of the injustice of Guam paying for its own war claims, every governor before us, current and past, every senator, current and past, every congressman, current and past, objected to war claims being paid out of our own funds, out of our own Section 30 funds. And I wish any senator success who wants to go to Congress and lobby to change that. And I sincerely wish them success, where no one has been able to change Congress's mind on that regard, to resolve that true injustice. But for us here today, in this bill, our goal is to fund the local war claims program that we have agreed to and promised, and not wait for FY23 Section 30, not talk about FY21 or 22 Section 30 that has already been appropriated by the legislature, that we deliberately spelled out on page 3 of our FY22 budget and appropriated to agencies. Why should we rehash that and potentially delay Manamco getting their payments? So we are, by this bill, allowing them to be paid immediately if we can, by the amendment, identify viable funds. And so we have received fiscal note after fiscal note after fiscal note about how FY21 excess revenues available to pay for programs today, and we should identify that in this bill. And we should tell them, we agree with you. use it for this purpose, not for any other purpose. And no, you do not get a free ride at the expense of the taxpayers of Guam to use the excess revenues however you want. We will be deliberate in how we lay out the expenditures of excess FY21 revenue. And as a legislature, we should exercise our supposed power and goal of checks and balances to dictate how excess revenues in FY22 will also be spent. Not to look the other way, continue to let the administration come down here and tell us that they're not going to tell us exactly which funds they're going to use, how much is left, and that we hold them more accountable than that. And we be more specific. And that why would we as a legislature not, require them to be more accountable, unless it's to our benefit to continue to make appropriation after appropriation from unknown sources without knowing how much is left, not knowing if it's viable, until we end up like previous legislatures, spending more than we brought in, promising more than we could ever pay for, and then someone not paying the refunds. And we end up in a debt so large that we have to borrow from future generations to pay refunds. And so, colleagues, I just ask you to keep the language intact that mandates that it will come from excess in 21, and that we deal with excess in 22 later, and that that we, if we want to suggest to future legislatures to recoup, I don't see why we need to recoup, because recouping from excess FY21 monies is restricting the legislature from the only federal funds that the legislature can actually appropriate, and gives to the executive branch, again, the ability to spend FY21 excess revenues however they please.
Thank you, Madam Speaker. On the amendment to the amendment, there has been an objection. Would you like to close, Senator Rachel?
Yes. Thank you, Madam Chair. I personally have no problem with changing the language from may to shall. For me, this is more of an issue of, whether we say it comes from the War Claims Fund, whether it comes from Section 30 funds, whether it comes from the general fund. Different pockets, same pants. So for me, it doesn't matter if it says shall or may. So I will support any amendment that changes it from may to shall. With that, I ask for my colleagues' support on this particular amendment. Thank you, Madam Chair.
Thank you very much, Senator Rajal. There has been an objection to the amendment. All those in favor signify by raising your hand. Amendment to the amendment. Amendment passes. We are still on the amendment as amended. We will take a moment's recess. We are back from recess. The amendment to the amendment has passed. There was originally an objection raised to the amendment. Senator San Augustine?
I raised the objection, and I'm going to withdraw it because now there's an amendment to the amendment.
Thank you very much. The objection to the amendment has been withdrawn. Any objections to the amendment? To the amendment as amended. This is the Terlahi-Duenas amendment. Are there any objections? Would you like to close?
Yes.
Speaker, you may close.
Yeah, I'll be brief. Thank you to my colleagues for their support of, trying to pin down the actual source so that we can account for it, the $62 million excess revenue that we helped to create by keeping ourselves within the budget and accountable. And that we may create an FY22 if we are fortunate, if Guam is fortunate, and that we can also hold them accountable too. So the underlying issue again is that the current source of funding in the bill without this amendment would just say general fund. It gives no year or specific language to ensure that we can account for the $62 million in excess FY21 funds. We asked them yesterday, the administration, and they either could or would not tell us the LEAP program, which also had the exact same language, general fund, if they were using FY21 excess or FY22 excess or what other source. So I just think that if we do nothing and put no specific language in there to identify the source and the year, and we will allow the administration to again pick and choose what they spend it on or where the funds come from. And at our limbo, because we will not in confidence be able to appropriate for other needs of the people of Guam if we cannot account for the excess revenues appropriately, especially those in FY22 coming up. So that my amendment would just make it very clear where these funds are coming from, hold them accountable. Hopefully they're not going to ignore any of these provisions that we've put in, as was happened in the original war claims bill or law. And then, we will be able to additionally take care of needs of the people of Guam if there are revenues without overexpending. The LEAP was an example, I think, where we just were too general, and so I'm hoping to improve upon that, and so that we don't get answers in the future from the administration of, that they won't tell us exactly where they're funding it or how much is left or anything like that. And so that we can just continue to do our job and use what is left in a responsible way. So, I hope that will promptly, immediately, and sufficiently fund the war claims up to $10 million, that the program can be implemented immediately with this funding. There will be no further delays, and more importantly, we can account for the FY21 $62 million in excess, and we can use the FY22 revenues, if they truly are in excess, appropriately going forward. But everybody has already accounted for this $10 million from FY21 excess. So that's what my amendment would do, and I thank the sponsors of the additional amendments to it, and I ask my colleagues for their support. Thank you.
Thank you very much, Madam Speaker. On the amendment as amended, hearing no objections, amendment passes. Speaker Terlahi, you are still recognized.
Thank you, Madam Chair. I have, I think there are 4 additional amendments. These are all amendments recommended by legal, and they're intended to do the same thing generally, and that is to reconcile. There are several provisions in the bill regarding privacy and disclosure and what will be disclosed, what is going to be private. So these 4 amendments together reconcile those provisions, but we can take them one by one. But they're all same purpose, same, very similar language in each of them.
Sure, we'll take them one by one. Please read out the line and page number for each.
Madam Chair, recommend that the amendment is going to be introduced, follow the sequence of the page, because the 4th amendment that goes to page 12, I would have to comment on that one. The
Thank
first
you
3, I have no objection.
Thank you very much. We'll try to take them in order. Just take a moment's recess. The Committee of the Whole is back from recess. Speaker Terlahi, you are recognized.
Thank you, Madam Chair. So the first amendment, we'll take them in order of the page number. This first one's on page 9. So it's titled TMT L21 to 22, P9, Privacy Rep. So this would amend Section 13.312A in Section 2 of the bill. And where it says simply documentation, we are adding documentation or information concerning the identity of war survivors, decedents, and their application for war claims shall be protected. We're also adding that an application for war claims shall include but not be limited to any statement of claim, materials, documents, forms, photographs, recordings, written testimony, and information submitted relating to or in support of a claim. So as you know, they fill out the claim form and they have to add attachments. So this is just defining what is included under the confidential documents, what is included as the application. All of these documents will be included, and so supposedly will be confidential.
Thank you very much. Madam Speaker, on the amendment, Senator Blas, you are recognized.
Thank you, Madam Chair. Madam Chair, just if the author of the amendment would yield to a question. The question is basically...
Excuse me, Senator Blas, can you please speak into the microphone?
If the
Thank you.
author of the amendment can yield to a question, the question pertaining to, it states here, the statement of claim, materials, documents, forms, photographs, recordings, written testimonies, and information. That word "and information," or that word "information," other than what has been previously, what are we talking about?
Do you yield to the question, Speaker?
I mean, sure, yes, I would yield to that question. I thank you for the question. Okay, so right now, applicants will be submitting the claims form, and the claims form mandates that they attach any material in support of what they are claiming. These include what's listed here: photographs, recordings, written testimony, but and then information submitted relating to or in support of a claim. Pretty much anything attached to that affidavit, that claims form, is what we're saying will be part of it. We don't know what those are yet because it depends on their what their injury that they're claiming. It might be medical records or something else, but we're saying whatever they attach to that form. To that.
Oh, okay.
Yeah.
I just wanted to make sure that this was not inclusive of already something that we already talked about, but that, in as far as an amendment to this is, before the word information, other pertinent. I'm going to ask.
Is that an inquiry? Or-
As an inquiry.
Okay, do you yield to the question?
Yes, if you could just restate where you would insert that.
Before the word information
After written testimony and information.
and other pertinent.
Information submitted relating to or in
Right.
support of a claim? Yeah, I have no objection to that.
Okay, there has been, we'll take a brief recess. The Committee of the Whole is back from recess. Senator Blas, you are recognized.
Thank you, Madam Chair. Madam Chair, after conferring with the author of the amendment and recognizing it may not be fungible, then I'll go ahead and withdraw.
Thank you very much, Senator Blas. Anyone on the amendment? Hearing no objections. No objections. Amendment passes. Speaker Terlahi, you are still recognized.
Thank you, Madam Chair. The next amendment is titled TMT L5P10 Privacy of Claim. So line 5, page 10, to amend 13.313A in section 2 of the bill. And it's the exact same language that we just passed. It's the definition of an application for war claims. So it's to add the words, an application for war claims shall include but not be limited to any statement of claim, materials, documents, forms, photographs, recordings, written testimony, and information submitted relating to or in support of a claim. Same language added to a different subsection of the bill.
Thank you, Speaker. On the amendment, line 5, page 10. Hearing no objections, amendment passes. Speaker Terlahi, you are still recognized.
Thank you. Next amendment is line 9, page 10, privacy of claims, to amend 13.313B in section 2 of the bill, to add the exact same words, an application for war claims shall include all these things. That's the exact same language from legal in the first and second and now the third amendment. Yeah. Thank you, Madam Chair.
Thank you very much. On the amendment, hearing no objections, amendment passes. Speaker Terlahi, you are still recognized.
Before I forget, I'd just like to thank legal for their work on these amendments, these technical amendments, their recommendations, and on the entire bill. A lot of the bill has been scrubbed, I think, with the work of the committee and the work of legal, and I want to thank them for that because it was a very complex bill, I think, with all the privacy concerns and the different provisions regarding what can be disclosed, privacy, of the information. They were actually, very confusing and somewhat conflicting. So I'm hoping that, we've done our best to ensure that these claims will be confidential. Okay, so this is final amendment line 5 to 21, page 12, it's an exhibit. Oh, well, no, it's regarding the exhibit. So this is to amend 13.314C in section 2 of the bill. So C says, the notice of disclosure contained in Exhibit A shall contain the following language. Okay, so we're making an amendment to what that notice of disclosure says in the exhibit. So the amendment would be where it currently reads, any material information submitted before or after this statement of claim in regard to or in support of the claim is now going to say any material and information submitted relating to or in support of the claim. It doesn't matter before or after this statement of claim. It's pretty self-explanatory. And we added the words will be protected and kept confidential instead of treated as public information, except when public disclosure of such information is authorized by, and then it lists different laws that might mandate very particular circumstances where that information will be disclosed, such as consent of the applicant and other exceptions. And then it dictates that the committee, we want the committee to be able to report on how many claims, the amounts, just like the federal government did. And so, but we changed the language to say that any decision issued by the committee in relation to this statement of claim may be made publicly available after redacting all information exempted from public disclosure by these other provisions or federal law, so that they may redact. And as we see on the Federal War Claims website, we can see war claims numbers and decisions that are made, but they don't tell us the identity on that website. That would be the amendment, Madam Chair.
Thank you very much, Madam Speaker. On the amendment, Senator Tydegui.
Just Madam Chair, I just have a question to the author of the amendment.
Please state your question.
Thank you. By striking out the middle section where it says, starting with the aforementioned information materials may be made available to interested persons, okay, et cetera, going down, and then program in conformity with the Freedom of Information Act. My question is that even with so this means that if somebody asks for Freedom of Information Act with some of this material, then it would not be able to be provided to that individual, correct? So it maintains its confidentiality even with the Freedom of Information Act taken out.
Well, I think even with those words changed as per the amendment, that they would continue to have to work with the Freedom of Information Act and the other statutes specifically named to ensure that what's the product of what can be released. So if you notice Title 5, Guam Code annotated, that is our, Article 13, no, I take it that back. But yeah, the Freedom of Information Act would still apply. However, this bill and this section of the code that we are enacting is making very specific exemptions to that. I guess that's how I'm describing it. Yeah.
So in other words, then nobody can request for Freedom of Information Act?
You can, of course, they always can
okay.
avail of the Freedom of Information Act, but what they are going to get in return is going to be with these exemptions considered as well.
With redacting some of the other
exactly.
information? Okay.
Yes.
Okay, thank you, Madam Chair.
Thank you very much, Senator Tydegui. On the amendment, Senator San Augustine, you are recognized.
Thank you, Madam Chair. My colleagues, what you see on the bill, on this specific page, line 5 to 21, information that was put in the bill is a result of the public hearing. and input from legal. So we just want to make sure it's clear. And this came from the author of the amendment, the input that was there. But I have no problem on you want to remove it, fine. My only concern is in the very bottom of the end, it says, and you strike out after the Guam Code annotated. That's the Sunshine Act. You're striking it out? That doesn't apply then? I just need to know if you yield to that question, the Sunshine Act, and if it doesn't apply, then so be it.
Thank you, Senator San Augustine. Speaker Terlahi, do you yield to the question?
Yes, I think the Sunshine Act is in Title V, correct, but it's in Chapter 10. But anyways, the article listed here that said Article 1.10 of Title V, according to legal, did not make sense. And so they figured out that it should be what's right before that, the Article 13.3 of Chapter 1 of Title V Guam Code annotated. I don't think the Sunshine Act, you know, it's Chapter 10 was ever properly listed in here. You know, so Title V, it includes FOIA, Sunshine. I think Sunshine is actually the open, well, no, it's the FOIA. It's the same. I think,
Right.
sorry, if I may just, I think all of our current laws continue to apply, except if this law says specific information shall not be disclosed, right? So you can continue to apply the Sunshine Act, make a FOIA request, and do all of those things that we have the right to do, except if this law now is saying that this particular information, so whatever it says in particular, that may be redacted, can be redacted.
Does that satisfy the question, Senator San Augustine?
Madam Chair, thank you from the author of the amendment. I'm not going to object to it. It just gives me fair warning that when I get comments in public hearings and legal review, I'm going to have to double check it. And thank you.
Thank you very much, Senator San Augustine. On the amendment, hearing no objections, amendment passes. Speaker Terlahi, you are still recognized.
That's my final amendment that I can remember here, Madam Chair. And I just want to thank my colleagues for their patience in these deliberations. And I want to thank the committee chair who took it upon, you know, the bill again was submitted by the governor and it required, you know, changes and a lot of work. And I know that the committee put in a lot of work. I know I reviewed many drafts and that I know our legal team also did the same. And so I just think that together with all of our work and deliberations here today, you know, that we can always take this opportunity to just correct any errors that I might have made myself, you know, and to just continue to do that as well. But I want to thank the committee for their hard work and my colleagues for allowing this bill to be considered today, you know, in this session as we promised, and hopefully get it passed by the end of the week so that we can get this program going. Situas Masi, Madam Chair.
Situas Masi, Madam Speaker. We'll move to the second row, beginning with Senator Perez for any amendments in this third and final round.
Thank you, Madam Chair. The first amendment is related to a previous amendment that was proffered in regards to giving the adjudication committee some flexibility in extending the deadline. And it was explained earlier that in addressing the claims for individuals that are survivors of the war, those have to be dealt with first before moving on to the second tier.
Madam Chair, what amendment are we looking at?
Okay, yes, it's amendment, page 5, line 23 to 27. It's to amend section 13.303B of section 2 of the bill to read, B, notice of filing period not later than 30 days after the date of enactment of this act. The adjudication committee shall publish a notice of the deadline for filing a claim described in subsection A of this section in a newspaper of general circulation, radio, television, media in Guam, and the Guam Public Notice website. The adjudication committee may extend the deadline for filing a claim upon submission of a quarterly status report to Y Legislature in Guam. And so this amendment was actually created during that recess period to address some of the concerns regarding extension of the deadline to encompass those claims that involved decedents of the war claims survivors. And so the priority is for, according to this bill, see if I can go back to that section. Okay, so if you look on page 4 of the bill, under section 2, so basically survivors of the compensable Guam decedents. In the case of compensable Guam decedent, the director shall pay $25,000 for distribution to survivors of the decedent in accordance with subsection B, and the director shall make payments under the subsection only after payments have been made to those that were survivors themselves. So this would give the opportunity, so I guess again it's about giving the Department of Administration flexibility to make sure that all claims are processed before finalizing the claims for those decedents of war survivors. And so I hope that addresses some of the concerns initially in regards to extending the deadline. So this is my amendment, or yeah, this is the amendment I'd like to proffer. Thank you.
Thank you very much, Senator Perez. On the amendment, Senator Blas, you are recognized.
Thank you, Madam Chair. Madam Chair, I'd just like to know if the author of this amendment can yield to the question. And the question basically is, what are we looking for in this quarterly status report?
Do you yield to the question, Senator Perez?
Yes, just give me one moment, please. So in the original law, Public Law 36-62, the reporting requirements are there, and it states that every 6 months, the Director of Administration shall submit a report summarizing the number of applications which have been submitted, adjudicated, and settled, which shall include information on all payments issued pursuant to this act. So I think previously it was stated that we need to monitor, I guess, there are priorities that are given to those who are war claims survivors. And so those have to be prioritized before moving on to the next level, which is the decedents of the war claim survivors. So should the war claim survivor have become deceased, then the next level is fulfilling the claims of those of descendants of those war claim survivors. So it's really about making sure that we fulfill the responsibility or the priority of the responsibility of addressing the war claim survivors fully, which according to this bill would have to be addressed first before moving to the the descendants. So it really allows more flexibility, so we can understand what needs to be done, because as the claims are coming in, we don't have a full idea of what needs to be, or what needs to be completed. So it's really just about gauging if more time is needed for the adjudication committee. I don't know if that answers the question.
Thank you very much. Senator Blas, does that satisfy your question?
Well, it does provide an answer to the question. Whether or not it satisfies me as to whether I can support this amendment or not, it doesn't. I have an old saying, what does this got to do with the price of Tang at Happy Mart? I'm just trying to connect a quarterly status report with the need, or with the possibility of extending a deadline. I just don't want the legislature, this body, to be held to be accountable, or to be held responsible for not extending a deadline if all the claims have not been filed. I'm a little worried about that. If there is a necessity to that, I remember all we're doing here is talking about a filing, not the payment. So what status report are we going to get from the filing period? This is not a payment period. Okay, so it really doesn't require any legislative action that we're going to need to take action on. So I'm just trying to find the reason as to why this is necessary when we're talking about just the filing period, not the payment period. This legislature's got the fiduciary responsibility to manage the funds, to appropriate the funds, and not to get into the operations of the government in this fashion. I'm going to have to object to this amendment.
Thank you very much, Senator Blas. On the amendment, Speaker Terlahi, you are recognized.
Yeah, I support the amendment. It's a very simple way of just getting feedback that's mandated, as some senators had concerns earlier regarding they need reports from this adjudication committee and did not trust that the media would adequately report on the progress of the adjudication committee as to how many claims they had received, how many they had processed, etc. So this simply says the committee may extend the deadline for filing a claim upon the submission of a quarterly status report to the legislature. So submission of a quarterly status report, I have no problem with that. Extending the deadline may actually be strategic if, as we talked about earlier this morning, we want to pay both categories 1 and categories 2 quickly. We can set an earlier deadline and continue to set those deadlines within the 1-year maximum period that is now provided in the law. Otherwise, all category 2 claimants will have to wait beyond 1 year to get any payment while the funds are sitting. Thank you, Madam Chair.
Sadius Masi, Madam Speaker. On the amendment, on the Perez amendment, Senator San Agustin, you are recognized.
Thank you, Madam Chair. As the previous speaker mentioned, we discussed that earlier this morning. That amendment failed. There's no 30 days or whatever she wanted. That amendment failed. If we want to talk about it, it's 12 months. It was also very clear and stated that we let the administration determine and state the deadline. Let's stay on our lane. And we'll let the administration do what we expect them and we demand that they do. to take care of all the war claim survivors. And then when they're done with that, then they can establish the next period to pay out the next group, the group 2. Because until they're done with group 1, they can't get to 2. And they've already stated what the period would be, and we'll move on from there. Thank you, Madam Chair.
Seduce Masi, Senator San Augustine, on the amendment.
Point of
Speaker
information,
Chalahi.
Madam Chair,
Please
just
state
want
your
to say,
point of
this, the administration did not set the deadline. The legislature in this bill is setting the deadline at 12 months. In our original law, we set no deadline. And we are clearly setting a 12-month deadline that they cannot work around, except perhaps by this amendment to allow additional time, not to provide less, but to allow more, perhaps. That's all. It doesn't harm. Anyways, yeah, I just wanted to make that point of information, that it was the legislature setting the deadline.
Thank you very much. On the amendment, there has been an objection to the amendment. All those in favor, please raise your hand. Would you like to
I'd like
close,
to
Senator
close,
Perez?
yes.
Yes, please go ahead.
Yeah, thank you, Madam Chair. So yeah, the reason why I proffered this amendment, because I feel the 12-month is an arbitrary number, and considering that the intent of the bill was to address those that did not file on time, and so whatever reason, we don't know what the reasons are. And I think by allowing this, it gives, it addresses the injustice of not having war claim survivors resolve the issues of, of the atrocities of the war. But I do feel that something that might be of assistance is really, there is a finite number, right? There's a finite number of individuals that can claim for this, considering that the claims stop at the children of the survivors. And so that number could potentially be calculated. And so if we're concerned about the cost, there is a way to address that. I think that would be a more, logical way if we truly want to bring closure to our survivors, to really encapsulate that group. So I think, I feel the 12-month is an arbitrary number, and perhaps, allowing the flexibility to the adjudication committee to ensure that those war claim survivors and their descendants can receive justice. So it's Masi.
Thank you, Senator Perez. On the amendment, there has been an objection. All those in favor, please raise your hand. Amendment fails. Senator Perez, you are recognized.
Thank you, Madam Chair. The next amendment is line 9, page 7. It's to amend the bill to read, "The adjudication committee shall do their due diligence in locating descendants should the claimant be deceased, and to allow legal to renumber and make technical corrections." The reason for this amendment is to, I foresee one of the issues is when it comes to awarding claims to descendants, that there's a potential issue with making sure that all the descendants are notified. And I think it's important that the adjudication committee become more proactive when it comes to this part of implementation. I think this could be a potential issue, and due diligence is one way to address that. And considering that our government is actually looking at, our other agencies are actually looking at this when it comes to land issues. We can definitely partner with like Department of Land Management, Chamorro Land Trust. I think they have the institutional knowledge when it comes to who the descendants are. And I think this, working with other agencies to do this, I think it would be an important proactive measure. Thank you.
Thank you, Senator Perez. On the amendment, Senator Titlegy, you are recognized.
Situus Masi, Madam Chair. You know, I would hope that the adjudication committee, you know, does their due diligence in every aspect of the word. And it's not just for those claimants who are deceased. I think any of those who are entitled to, and locating them, I mean, that's why we got in this predicament in the first place. You know, we just, we could have done better. You know, we could have put more advertisement out there. We could have had a committee that actually reached out to certain areas or relatives and find other ways. I think this committee put together, which is made up of the 5 individuals, is a good start to sitting down and talking about what are ways that we can do as a committee to reach out to those who've missed the deadline, or, you know, who've been like maybe living in Georgia, somewhere in the woods back there, you know, finding some kind of way to contact these individuals. And I think they're doing their due diligence when it comes to, I hope that they do, but by just looking and doing their due diligence in locating descendants, it shouldn't just be those who are deceased. I think it should be everyone who's entitled. So if I can, I'd just like to make an amendment to the amendment and just strike out, should be the claimant be deceased. And then I'm hoping that would just cover everybody, you know, and doing their due diligence in locating. Well, actually, Madam Chair, if you give me 1 second, because I think it's more than that. What I'm trying to do here is just, it may not even be needed. You know, we have to anticipate that the adjudication committee will do their due diligence, but, you know, nothing in here indicates that they have to go beyond and try to locate individuals
Okay.
that are entitled. So let me see what I can do on
Thank you.
on
If
this.
you are offering an amendment to the amendment, we will need it in writing. We'll take a moment's recess.
Okay, thanks.
Committee of the Whole is back from recess. Senator Perez, you are recognized.
Thank you, Madam Chair. I will withdraw my amendment. I'll make the motion to withdraw my amendment. Legal is working on drafting it at this time.
Thank you. On the motion to withdraw the Perez amendment, are there any objections? Hearing none, motion passes. Senator Perez, you are recognized.
Thank you, Madam Chair. So I want to proffer the next amendment, which is on line 11, page 7, is to amend the bill to read objections. So this is in the appeals section of the bill. And objections and appeal, it reads, to amend the bill to read, objections and appeals of the decision of the adjudication committee shall be to the committee, who shall consult with the Office of Attorney General, and upon rehearing the decision, each claim shall be final and not subject to further review. So this basically addresses the concern I have regarding appeals to the same committee that made the decision, and with this, in this case, requiring that legal representative be present to resolve any questions or maybe help provide information to help the committee make a fair decision. So this is the reason for this amendment.
Thank you very much. On the Perez amendment, Senator San Augustine, followed by Senator Titlegy.
Madam Chair, I'm just curious on maybe the author can explain it more and more detail. When the adjudication committee meets, the decision is final, and upon objection and appeals of the decision of the adjudication committee, the way the bill reads, it'll be final. So what consulting requirement is there from the AG? It takes a while to get a legal opinion, so I mean, I'm just curious. What are they going to be consulting about? The process of how it's supposed to be processed? On why they decided it, based on what's listed on the requirements to pass? If the author can explain more in detail so we can have a warm and fuzzy feeling to accept the AG's opinion of what's decided by the commission itself. Thank you, Madam Chair.
Thank you, Senator San Augustine. Senator Perez, do you yield to the question?
Yes, I do. And, really it's about having that legal perspective when it comes to adjudication. There are laws in place. So, for instance, if the committee needs guidance on interpreting or any laws that they would need to consider, I think it's always helpful to have a legal representative there to assist. So it's more about assisting the committee in coming to a resolution. So I think this would only add a benefit to the committee in helping them come to a decision. Because I think one of the issues that I have with the appeals process is the same committee that adjudicates a claim is going to appeal the claim or hear the appeal of the claim. And I think with the legal representative present, with their expertise, they could perhaps provide expertise on making these sort of judgments. Hope that answers the question.
Thank you. Senator San Augustine, does that satisfy your question?
Not really, Madam Chair, because number one, if anybody's going to appeal any decision made by anybody in any circumstances, they would get an attorney. And to get an attorney to get involved in what happens in the adjudication committee, if the adjudication committee feels that they need the attorney's advice, they would invite them. So I have serious reservation about this because the Attorney General is not for anybody else but the adjudication committee. So I don't see a need for them to have to go to the AG's office. There are checks. There's a checklist that they have to follow. They meet the requirement, so be it. They move on. It never happened with the federal government when they did the first issuance of this, where they had the United States Attorney General's office advising them. They have a checks. They go to the checks, check off, move on. Thank you, Madam Chair.
Thank you, Senator San Augustine. On the Paris Amendment, Speaker Terlahi.
Yeah, I would make an amendment to the amendment to change the word shall to may. And I agree with the former speaker that if we do not need to consult the Attorney General, for example, they just point out an error literally that we made in reading the documents or something that's simple, no need. If there's a need, then I think it seems expected to me that this is a committee of the government of Guam. It's absolutely entitled to the legal services of the Attorney General's office, even without mentioning it. But so my suggestion is to change the word shall to may.
Are you going to offer an amendment, Speaker? Okay, we'll take a moment's recess.
Never mind then.
Okay.
Madam
Amendment.
Madam Chair.
Senator San Augustine?
I would hope that the previous speaker would introduce that amendment. Otherwise, I object to this amendment. Thank you.
Thank you very much. There's been an objection on the amendment. Senator Titlegy, you're recognized.
Madam Chair, then I would like to make that amendment that change from shall to may, and do it without having to write it down, because it's a simple scratch out shall and put may.
We're not accepting any amendments at this time that are not in writing. So we'll take a moment's recess. You can proffer the amendment in writing.
Can we go on to the next?
The Committee of the Whole is back from recess. Senator Perez, you are recognized.
Thank you, Madam Chair. So yes, I'm going to,
Senator Titlegy, you are recognized.
Thank you, Madam Chair. I think I do still have the floor. At this time, Madam Chair, I'd like to withdraw making an amendment from from shall to may. After talking with the author of the legislation, I think we've come to a compromise here to simplify it. So thank you, Madam Chair.
Okay, thank you. Senator Perez, you are recognized.
thank you, Madam Chair. So I'm going to make that change. So what I'll do is I'll withdraw this amendment and resubmit the amendment.
On the motion to withdraw the amendment, hearing no objections, motion passes. Senator Perez, you're still recognized.
I'd like to request a 1-minute recess to submit it to clerks.
We'll break for 1 minute.
Thank you.
The Committee of the Whole is back from recess. Senator Perez, you are recognized.
Thank you, Madam Chair. So I would like to proffer this new amendment, which changes the shall to a may. It's the same amendment that we were addressing earlier, which says objections and appeals of the decision of the adjudication committee shall be to the committee who may consult with the Office of Attorney General.
On the amendment, Senator San Augustine?
Madam Chair, I rise in support of this amendment. It fits the circumstances. Thank you.
Thank you very much. On the amendment, hearing no objections, motion passes. Amendment passes. Senator Perez, you're still recognized.
Thank you, Madam Chair. So the next amendment I'd like to proffer is on line 21, page 12. It's to add a new subsection to read D. All agents implementing this chapter shall undergo disclosure and confidentiality training and shall be in compliance under Guam law. So in addition to the mandates of this bill, which requires a disclosure, so there's a lot of references to the laws requiring disclosure. Just as important as it's stated in this bill, I think just as important is the training of those that are implementing this chapter, that they are aware of the disclosure requirements and abide to that. Considering that it's not just, a few people, it's an adjudication, it goes beyond the adjudication committee, it goes beyond the repository, it goes beyond even the representatives of the claimants. So there's a lot of hands in this, and I think it's important that all those that are implementing this chapter understand what the laws are and abide by them. It takes more than just having the law in place, but the actual implementation is what's going to ensure that disclosure and confidentiality is maintained.
On the amendment, Senator Rangel, you are recognized.
Madam Chair, I request a recess until tomorrow at 9 a.m.
Is that a motion?
Yes.
Okay, there's been a motion to recess. There is an objection. All those in favor of recess until 9 a.m. tomorrow morning, please raise your hand. Motion passes. We are in recess till 9 a.m. tomorrow. Thank you.